Call to order the Platting Board meeting of April 3rd, 2013 at 6:31 p.m. Can I have the roll call, please?
Lendell Story,
Here.
Stephen Abel, Ken Fuller,
Here.
Daniel Young, Brent Cole, Anthony Cange,
Here.
Trevor Edmondson,
Here.
Clayton Walker,
Here.
Christina Enix.
Here.
Thank you, and we have a quorum. Agenda changes. There has been a request to change the order of the items under new business, and the request is to, let me look here, change to hear case S11976-1 before we hear case S11967-1. Can I get a motion to request the change or to approve the change, please? The request is to change the order of the items under new business for the public hearings and to change to hear case S11976-1 before we hear the second case, S11967-1.
Mr. Chair, I move to amend the agenda.
Mr. Cange moves to change the agenda, and Mr. Edmondson seconds. Is there any discussion? Is there any opposition? Seeing none, the motion passes. We don't have anything under special order of business. Oh, we do have under special order of business. Are there any disclosures? Mr. Edmondson.
Yes, Mr. Chairman, in case S11976-1 Fairview Subdivision Extension Number 1, I'd just like to disclose that my firm, the Peterson Group, is in numerous contracts and has numerous deals with Cook Inlet Housing Authority. However, we are not involved in the project or involved in what's before us tonight. So therefore, and we have I have no private or financial interest in the project that's before us tonight. So therefore, I feel like I can act impartially in this case.
Thank you. Can we have a motion regarding the conflict of interest for Mr. Edmondson?
I move to direct Mr. Edmondson to participate in the case.
And Mr. Fuller seconds. Have a discussion on the matter?
Doesn't sound like he has a substantial interest in the present action, that he has any direct or immediate benefit that would come from his participation in this action. And I think that it would be fair and reasonable to have him participate.
Thank you. Is there anyone else that would want to speak to the motion? Are there any objections? Seeing none, the motion passes. Are there any other disclosures?
Yes.
Ms. Enix.
My company has done business in the past with Cook Inlet Housing, but I do not have any financial interest or personal interest in this case, and I feel like it can be a fair and impartial board member.
Thank you. Can we have a motion to approve? Or direct to participate?
I would move to direct Ms. Enix to participate in the case also.
And Mr. Edmondson seconds. Can you speak to your motion?
Again, it sounds similar to the last one. She doesn't have a financial interest in this particular project. She has had some doings in the past with the participant. However, I believe that any interest she might have had is remote at this point, and she should go ahead and participate.
Thank you. Is there anyone else that would like to speak to the motion? Are there any objections? The motion is approved. Are there any other disclosures? Under special order of business, there are informational items, the abbreviated plats, action summaries for 318.13 and 325.13, and no action required. We'll move on to the consent agenda. On the consent agenda, we have one time extension for S10990-7 West Park subdivision. Can we have a motion to approve the time extension, or the consent agenda, excuse me? Mr. Kange and Mr. Edmondson seconds. Can you speak to your motion? No. Okay. Any objections? Seeing none, motion is approved. I'll move on to new business. Read this first. Yeah. The procedure by which the public may speak to the Platting Board at a meeting is, after the staff presentation is completed on the public hearing item, the chair will ask for public testimony on the issue. Persons who wish to testify will follow the time limits established in the Commission Rules of Procedure. Petitioners, including all his/her representatives, have 10 minutes. Part of this time may be reserved for rebuttal. Representatives of groups, community councils, PTAs, etc. have 5 minutes, and individuals have 3 minutes. When your testimony is complete, you may be asked questions by the board. You may only testify once on any issue unless questioned by the board. Any individual may have appeal rights relating to any action the Platting Board takes. Appeal of this decision or any of the conditions is governed by AMC 21.11.304. The decision of the board at the scheduled public hearing shall become final 7 calendar days after the date the decision is made on the record, unless a written request is submitted to the Planning Division prior to the expiration of the 7th day to prepare a written decision based upon the record made at the hearing, and the request is accompanied by a written notice of intent to appeal. Adoption of the written decision by the Platting Board becomes the final appealable decision. Within 20 days of the final appealable decision, an interested party must file with the municipal clerk a written motion alleging new evidence or changed circumstances per AMC 21.11.503, or B, an appeal of the board's final appealable decision per AMC 21.30. The first case tonight is case S11976-1. Fairview Subdivision, extension number 1. Can we have the staff's presentation?
Thank you, Mr. Chairman. This is a preliminary plat that requests subdivision for one tract of land into one lot with the vacation of that portion of a 66-foot section line easement located along the north property boundary. Just to give you a bit of the property history, on March 1st, 2010, the platting officer approved a preliminary plat for tracks 8A, 9A, and 11A for Fairview Extension Number 1 under an abbreviated short plat process. Review of this preliminary plat found that the property was encumbered by a portion of a 66-foot wide section line easement along its north property boundary. On August 4th, 2010, the Platting Board approved the vacation of a portion of that 66-foot wide section line easement due to the unforeseen issues in obtaining approval from the State Department of Natural Resources and the Alaska Department of Transportation and Public Facilities. The vacation was not recorded and subsequently expired. Since that time, petitioner has worked diligently with the DNR and ADOT to obtain their approval on this vacation request. This action before you tonight is to complete that plat and vacation. In reviewing the vacation request, it appears to conform to the municipal vacation policy and ordinance. The property adjoins Mountain View Drive, which has a 35-foot wide dedication for the south half of the right-of-way. A 5-foot development setback is required along the north petition site boundary to meet the OSNHP standard to provide an 80-foot right-of-way for a Class II minor arterial. Generally, reviewing agencies had either no comment or no objection to this vacation request. Access to adjoining properties is provided by dedicated and constructed rights-of-way. Traffic circulation will not be adversely affected by the vacation of this section line. The section line easement appears to be access to municipal need for right-of-way. With that being said, staff would like to recommend approval of the request, subject to the conditions listed on pages 6 and 7 of your staff packet. Thank you.
Thank you. Are there any questions for staff?
I just have a quick question. And just maybe for my clarification, when we talk about the requirement for this section line easement, and we state in the packet that it appears to be in excess to municipal needs, how is that determined? Is there some sort of test for that, or how do we come to that conclusion?
Through the chair, Mr. Kange, section line easements typically are reviewed when we send them out through different municipal agencies. Primarily, traffic is the deciding factor in whether or not the section line easement is vacated through the municipality. The traffic department did not have any objection to this. The petitioner will have to go through the state and DNR to vacate their interest in the section line easement. So that was the deciding factor.
Okay, thanks. And I just flipping through the agency comments, traffic didn't have any comment, and it seems like none of the other agencies really had any issues or no objection or no comments. Is that right?
Through the chair, Mr. Kange, that is correct. This vacation request has already come before the board once before. It was approved. However, it did expire, so the petitioner has to come back in. Yeah, there have been no objections to this request at all.
Great. Thanks for clarifying that.
Thank you. Are there any other questions for staff? Seeing none, can we have the staff's presentation, please? Or petitioner's presentation, please. Can you state and spell your name for the record?
Yes, good evening. My name is Tamás Deák. D-E-A-K is the last name. T-A-M-A-S is the first name. Thank you, Mr. Chair. Thank you for everyone for this very short, I think, presentation. And before I say anything, I really want to thank the staff. Dave has been working with me on this. Dave Whitfield has been working with me on this for a while. What happened is actually a thing which I would want to call your attention to because it may come up again. The discovery of the section line easement did not happen through the review. It happened through an adjacent parcels review for title reports. The title report did not have this vacation right away, rather a section line easement in it. We discovered it basically getting ready to construct. We had to make a decision. The petitioner, of course, Coconut Housing Authority, me being representing them, went for a vacation request, which was approved about 5 months later than the original plat. We were counting the 18 months from that date of the review and the approval, and we are obviously counting wrong, as we learned, because it was counted from the original approval of the plat. So that's one note to you next time if it comes in front of you, and maybe to staff, that that if the summary of action states that the approval is for 18 months for the plat from that decision, it should be clarified that the decision has to be from the plat, preliminary plat, rather than the vacation. That's more of a technicality, but I wanted to bring it up because the only reason we are here today is because we could not record this vacation without having a valid preliminary plat, which we did not have at that point. So today here we are, we bring in this project in front of you. The project is actually so far completed that there is a building on it with a certificate of occupancy. It has been occupied since 2011, and finally DNR approved the vacation of the state's right portion of the right-of-way. Also did the Department of Public Transportation. So we are ready to record, and when this is approved, then we're going to go and file a final plat to have our project completed. So in that, we have no objections to any of the conditions. The reviews have been made in the prior go-arounds. That's why you had fairly light reviews on this one. The project has been completed, and I really want to thank again staff who has been very helpful to get this to this point so we can move on and close out this project. With that, if you have any questions, please ask those questions, but I will reserve my time for rebuttal if there's any left. Thank you.
Thank you. Are there any questions for the petitioner? Thank you. The meeting is now open for hearing to the public testimony. Is there anybody in the audience that would like to testify? Anybody at all? Any rebuttal? Thank you. The public hearing is now closed and the matter now rests with the board. Can we have a motion to approve? Mr. Edmondson.
I actually have a question. Do we, this is for point of order, do we need to, can we approve both of these actions in one motion, or are there two different motions? Okay.
Mr. Edmondson, Mr. Walker seconds. Can you speak to your motion?
Mr. Chairman, in case S11976-1 Fairview subdivision, I move for the approval of the request to vacate that portion of the section line easement running east-west along the north petition site boundary, subject to conditions A, B, and C as outlined in the staff packet on page 51 and 52.
Excuse me, Mr. Edmondson, the motion should be just for A, 1 and 2.
Apologize, I was working off the wrong sheet of music here. So, will you restate my motion, please?
Thank you.
In case S11976-1 Fairview subdivision, I move for the approval of the request to vacate that portion of the 66-foot section line easement located along the north property boundary, subject to conditions 1 and 2 as outlined on page 6 of the staff packet.
Thank you. And Mr. Walker seconds. Can you speak to your motion and provide findings, please?
Sure. I'd like to, say that this has been previously approved, and that this previous action had expired, and that there appears to be, there's been no comment or objections by the reviewing agencies or by the public, and that the right-of-way and section line easement appears to be in excess to the municipality's needs.
Thank you. Is there anyone else that would want to speak to the motion or provide additional findings?
I think it's also important that the property owners there have already taken action in reliance on the prior vacation, and that the construction that was anticipated by this development has already taken place, and it would be an undue hardship to not now grant the vacation.
Thank you. Is there anyone else that would want to speak to the motion or provide additional findings? Thank you. Are there any objections to the motion? Seeing none, the motion is approved. Can we have a motion to approve item B? Mr. Edmondson. Ms. Enoch seconds.
See if I can read off the right sheet of music this time. In case S11976-1 Fairview subdivision, I move for the approval of the plat for 18 months subject to conditions 1, 2, and 3 as outlined on in staff's packet on page 6 and 7.
Thank you. Would you like to speak to your motion and provide findings, please?
I'd just like to comment that that it has staff's recommendation and approval, and that there appears to be no public comments, and there seems to be support by agencies that reviewed the plat.
Thank you. Is there anyone else that would like to speak to the motion or provide additional findings? Are there any objections to the motion? Seeing none, the motion is approved. Any individual may have appeal rights relating to any action the Platting Board takes. Appeal of this decision or any of the conditions is governed by AMC 21.11.304. The decision of the Board at the scheduled public hearing shall become final 7 calendar days after the date the decision is made on the record, unless a written request is submitted to the Planning Division prior to the expiration of the 7th day to prepare a written decision based upon the record made at the hearing, and the request is accompanied by a written notice of intent to appeal. Adoption of a written decision by the Platting Board becomes the final appealable decision. Within 20 days of the final appealable decision, an interested party must file with the municipal clerk either A, a written motion alleging new evidence or changed circumstances per AMC 21.11.503, or B, an appeal of the Board's final appealable decision per AMC 21.30. The next item on the agenda is case S11967-1, Cranberry Ridge subdivision. Can we have the staff's presentation, please?
Thank you, Mr. Chairman. This proposed subdivision will subdivide 3 lots into 10 lots and includes a request for a variance from lot depth to width ratio, cul-de-sac length, and legal and physical access. The petition site is a 65-acre site located on the north side of Eklutna Lake Road. The land to the north and east of the site is either owned or managed by Chugach State Park. The site was zoned R10SL, and the special limitations state that the lot shall have a minimum area of 2.5 acres. All of the proposed lots meet this requirement. The site is steeply sloped and drops nearly 350 feet, or about 40% slope in places. Access to the site is from Eklutna Lake Road via Cranberry Ridge Drive. Cranberry Ridge Drive is located in a 60-foot wide, 20-year renewable right-of-way grant that crosses a BLM tract. The current term of the grant expires in February of 2014. And as access is not permanent, a variance from legal and physical access is required. The applicant has asked for a variance from lot to depth to width because lots 1 and 2 are just shy of the 1/3 ratio that the lots need to meet. And the request from cul-de-sac length is required because the maximum length is 900 feet and the cul-de-sac length is nearly 2,400 feet. So I'm going to speak to the standards for the variance requests. Standard number 1 speaks about having special circumstances or conditions affecting the property. Staff finds that this standard is met. The subject property is steeply sloped and oddly shaped. The variance from depth to width is de minimis. And the variance from cul-de-sac length is warranted given that no further extension of Twin Peaks Circle would be possible because the property directly north and east is either owned or managed by Chugach State Park. Regarding the variance from legal and physical access, this access has no access to a publicly dedicated street, and the only means of access is via the right-of-way grant from BLM. BLM does not grant permanent easements, and BLM is knowledgeable of the proposed subdivision and has provided comment. According to BLM, it is extremely rare for the BLM to revoke a right-of-way grant. The second standard is that the variance will not be detrimental to the public welfare. This standard is met. All 3 variances have no impact on the surrounding properties in the area. The third standard speaks to whether or not the variance will nullify the intent and purpose of the regulation. This standard is met. The intent of the lot depth to width ratio is to ensure efficient use of land and developable lots. Given the steep slope of the site, the de minimis variance is warranted. The intent to limit cul-de-sac length is to provide connectivity to future development of adjacent properties, and since this is abutting Chugach State Park, that is not possible. The intent of the requirement to provide physical and legal access is to provide assurance to future property owners that they will have access to their property in perpetuity. Like I said, the BLM does not grant permanent easements, and a long-term right-of-way grant is the only option for this property. Under the North Anchorage Land Agreement, this property is identified as litigation settlement lands to go to the state, and when the land transfer occurs, the property will be transferred to Alaska State Department of Natural Resources. This government agency has more flexibility and may be able to provide a permanent easement. Well, it's currently not memorialized in a perpetual easement. The municipality feels that there is reasonable assurances that the BLM will continue to provide access to the site in perpetuity, and we've added several conditions to the plat to ensure that. We added a plat note. Our proposed conditions include a plat note that explicitly states that access via Cranberry Ridge Drive is through a right-of-way grant, and it is the responsibility of the homeowners association to maintain and renew the right-of-way grant. We have a condition to require that the homeowners associations that describe this responsibility be recorded concurrently with the plat. Since the right-of-way grant right now expires in 2014, we would like that to be renewed for another 20 years prior to the plat being recorded. And we also need to ensure that we have written authorization from the BLM to improve the street that's located within the right-of-way grant. The fourth standard is that undue hardship would result from strict compliance. This standard is met, staff finds that the standard is met. Strict compliance with the subdivision regulations would require that Twin Lakes Road be extended to the east boundary if in regards to the length of the cul-de-sac. And this is undue hardship since there is no opportunity for the street to be extended. The proposed plat is based on an existing driveway that has been developed on the site, and given the de minimis nature of the lot depth, the width ratio, strict compliance would also result in undue hardship because another road alignment would be required. And finally, regarding the legal and physical access, since there is no permanent access to the site other than the right-of-way grant, no subdivision could be approved without a variance from legal and physical access, resulting in a hardship. So therefore, the staff recommends approval of all three variances and approval of the plat subject to conditions 1 through 12 on pages 10, 11, and 12 of the staff report.
Thank you. Are there any questions for staff? Seeing none, we are open now for public hearing. Can we have the petitioner's presentation, please? And please state and spell your name for the record.
Mr. Chairman, board members, my name is Kenneth Lang, L-A-N-G. I'm here this evening on behalf of the petitioners, Steve and Cheryl Remy. Mr. Remy is here also, and he's available to answer any questions you may have. I'd like to start by commending staff for their outstanding job that they did in bringing this case to a point where it could be presented to you. We had some initial, or they had some initial concerns over the access issue. This property was patented by the BLM without any actual legal access, and it has always been accessed off Eklutna Lake Road by this granted renewable permit. I'd like to start also by saying that Mr. Remy has retained an attorney to prepare homeowners association documents. They're supposed to be ready within the next few days, and as soon as that is taken care of, he is prepared to go to the BLM and start the renewal process to extend the permit for another 20 years. One concern we had in the staff report is the regarding slopes. The topography, this is an R10 SL zone, which is generally indicative of steep slopes, but the steep part is really only in lots 1 through 3. Lots 4 through 10 have an average slope of 10% or less. 1 and 2 get steeper as you go north towards the back of the lots, and the back portion is about 40%, which is unbuildable, and that helps justify our variance because the back portions of the lots will not be used. The adjacent properties are to the east. The property to the east is actually owned by under the ownership of the Eklutna Native Association, and the property to the south where the Eklutna Lake Road is still owned by the BLM. It all falls under the North Anchorage Land Agreement, which was prepared several years ago, and under the agreement, the Chugach State Park access to Eklutna Lake is on these properties, and with a number of trails on the portion owned by Eklutna. The agreement is that Eklutna will exchange their parcel for another similar parcel in another part of Eagle River. And it will all be eventually go to the state DNR and Division of Parks. The other comments I have really have to do with the actual staff recommendations. Excuse me. And it's on page 10 of your packet. Just for your own information, number 5 is providing additional stream mapping, and I applied for that at the same time that I met with the Watershed Management Services people to have them sign off on our application. They said they'd be getting to it early or late spring, as soon as the snow melts and the streams start flowing. The other item is in 6A, soil tests were performed last fall on all of the lots, and they all passed. Mr. Remy tells me tonight under item E, the comment is his existing well is not documented, but he assures me he does have a well log and will be turning it in. And I had one other comment on page 12, item 11A. Talks about Cranberry Ridge Drive not being a dedicated street, and that this will be a plat note that the homeowners association will maintain and continue to renew the grant to ensure continued access to the subdivision. And I would just suggest that you might add at the end of it, just the wording, until such time as a permanent easement is granted. That gets the homeowners association off the hook in the end, if and when the easement is available. Other than that, I would be happy to answer any questions you may have, and I don't think it'd be necessary to reserve the remainder of my time for rebuttal, but we're here.
Thank you. Are there any questions for the petitioner? I did, just for clarification. So you just had comments on the staff or the department's recommendations, and the only addition or that you had was on 11A?
Yes. Yeah, the rest of them were in general agreement with them.
Okay, thank you. Are there any questions for the petitioner? Mr. Edmondson.
Mr. Chairman, Mr. Lang, could you repeat the language that you suggested we add to, I think it was condition 11A?
Maybe. Until such time as a permanent easement is granted.
Thank you.
And I do have a question for staff. Is the staff okay with that addition to
Mr. Chairman, that would be fine.
Thank you. Thank you. Meeting is now open for public testimony. Is there anyone in the audience that would like to testify? Seeing none, would you like any rebuttal time? Thank you. We are now closed the public hearing. The matter now rests with the board. Can I have a motion to approve? And actually, this case will require 4 motions, so we have a motion to approve item A.
Mr. Chairman, I actually have a question for staff. What happens in 20 years if there is not a permanent easement granted and BLM does not extend the access that they appear to be willing to do at this point?
Through the chair, it's not permanent. It has the possibility of not being renewed, but I think BLM has communicated to the municipality to our satisfaction that it is a very unlikely possibility, since they don't have in their toolkit the option of giving permanent easements. The road inside the neighborhood, inside the subdivision, will be a publicly dedicated road. So I feel like that adds a little bit more leverage to the situation, sort of in a way brings the municipality at the table, since it's our road on the other side of the easement. So I feel like that's could be helpful if there were a situation like that. But the reason why we are putting it forward is because we feel like the chance of that happening are de minimis. But if it were to happen, then there would be not a continuous access to the street.
So there is the possibility that there could be homes built on these lots that, say, 20 years from now may have an access issue.
There is a small possibility that they would have an access issue. It's not a permanent easement.
Okay, thank you.
Are there any other questions?
Just wanted maybe for my clarification. So the BLM never gives a permanent easement? If so, would making 11A with that statement that the petitioner requested have any bearing?
Through the chair, given the land exchange, there is this long-term option, or this long-term vision that this land would eventually become under state ownership, and at that time, when it's under DNR, they have more flexibility to grant easements. So that would be the scenario.
Okay, thank you for clarifying that.
Are there any other questions? Seeing none, can I have a motion to approve item A under department recommendations on page 9, please? Mr. Kange and Ms. Enoch seconds.
Thank you. In case S11967-1, I move to approve the variance from AMC 21-80-300D.
Thank you. Can you speak to your motion, the standards, and provide findings?
Yes, thank you. I believe that the 4 standards have been met in AMC 21.80.300D. I want to point out several of the conditions. Based on the subject property and looking at the topographical map, as it's noted in our staff packet, the subject property is steeply sloped and oddly shaped. So I think that standard has been met for the variance. I believe that this first variance will not have an impact on the surrounding properties in the area. I also believe that, again, given the steep slopes of some of the sites, and we want to make sure, the petitioner wants to make sure, and the city, that there's, I guess, efficient use of the land and to be able to develop these lots. So I feel that standard 3 has been met, and I do feel for undue hardship, with this variance in place, the strict compliance would reduce the number of developable lots, and I find they're all in compliance with what they're zoned for. So I believe that standard has been met, also standard 4.
Thank you. Is there anyone else that wants to speak to the standards or provide findings to the motion? Seeing none, are there any objections to the motion? Seeing none, the motion is approved. Can we have a motion for item B under department recommendations on page 9? Mr. Kange, Mr. Walker seconds.
Thank you, Mr. Chair. Again, in case S11967-1, I move to approve the variance from AMC 2180240.
Thank you. Can you please speak to your motion, the standards, and provide findings?
Sure. Again, based on the comments, the petitioner's comments, as well as the findings in our staff packet, I do believe that the 4 standards have been met. To approve this variance, specifically, wanted to point out that, you know, the property has no access to a publicly dedicated street, and given the fact that BLM doesn't grant permanent easements, I feel that it would cause undue hardship to have the variance in place. Additionally, it doesn't impact the surrounding properties in the area, and it's really up to the homeowners and the homeowners association to seek this easement. So I feel that those standards have been met, as well as, you know, again, given the property sloping and oddly shaped and the dedicated roads, that leaving this variance in place would cause undue hardship. That's all I have on that one.
Board Member Kange, were you saying leaving the variance in place would cause undue hardship?
No, not approving the variance.
Not approving the
Correct.
variance. Thank you.
Mr. Edmondson.
I'd just like to add to the findings that the intent of the limit to the cul-de-sac length is to provide connectivity to future development of adjacent properties, and that given that this site is surrounded by the park, to the north and the east, variance for the cul-de-sac length does not nullify the intent of the regulation. So there would be no need to provide access to surrounding properties. So I think that that helps meet the conditions and standards at number 3 as well.
Thank you. Does anyone else want to speak to the motion, the standards, and provide any additional findings? Are there any objections to the motion? Seeing none, the motion is approved. Can we have a motion to approve item C under department recommendations on page 10? Mr. Walker. Mr. Kange seconds.
As to S119671, I move to approve a variance from AMC 2180200, the design standards and legal physical access. municipal code requires properties to have a legal and physical access. This particular property has legal access, it's just not permanent access. But due to the existing agreement and the expectation of a settlement between the feds and the other people with property ownership in the area, it appears that it's only a matter of time before actual legal access will be permanent. And delaying development in the area would be an undue hardship on the present property owners, and the variance should be granted to allow development at this time.
Thank you, Mr. Walker. Is there anyone else that wants to speak to the motion, the standards, and provide any additional findings? Mr. Kange? Thank you. Is there anyone else that would like to speak to the motion or provide any additional findings? Mr. Edmondson.
Mr. Chairman, I'd also like to note that testimony by both the petitioner and staff mentioned a potential land trade between Clutna and the state that would help the petitioner get permanent access to the site.
I just wanted to clarify. I had heard the comment that this being an easement, but just to clarify that it is not an easement.
I'm sorry, I misspoke. It is an easement, though.
It's a permit, isn't it?
Oh, right-of-way grant. Sorry. I was looking at permanent easement on my sheet. Yes, right-of-way grant. Thank you.
Thank you. Is there anyone else? Thank you. Are there any objections to the motion? Seeing none, the motion is approved. We have a motion for approval of item D under department recommendations on page 10, please. Mr. Walker, Mr. Fuller seconds. Thank you. Would you please speak to your motion and provide findings, please? Thank you. Is there anyone else that would like to speak to the motion or provide any additional findings? Mr. Edmondson.
Request to speak there.
Okay. Thank you. Are there any objections to the motion? Seeing none, the motion is approved. Any individual may have appeal rights relating to any action the Platting Board takes. Appeal of this decision or any of the conditions is governed by AMC 21.11.304. The decision of the Board at the scheduled public hearing shall become final 7 calendar days after the date the decision is made on the record, unless a written request is submitted to the Planning Division prior to the expiration of the 7th day to prepare a written decision based upon the record made at the hearing, and the request is accompanied by a written notice of intent to appeal. Adoption of the written decision by the Platting Board becomes the final appealable decision within 20 days of the final appealable decision. An interested party must file with the municipal clerk either A, a written motion alleging new evidence or changed circumstances per AMC 21.11.503, or B, an appeal of the Board's final appealable decision per AMC 21.30. Next item on the agenda is reports. Seeing none. Any board comments? Seeing none, can we have a motion for adjournment? Mr. Edmondson and Mr. Walker seconds. Thank you.